Hi everyone, my name is Lauren Rote, and I work with John at Kinney and Korman. I think we're just making sure our mics are good. Is it too loud, or can everyone in the back hear us? Okay. And is it all right if we sit to present? I think it'll be easier because we're going to switch back and forth on different topics, so that's okay with everyone. Thank you all so much for having us. I guess I will kind of start off while John's getting mic'd and just say that if you have questions, if we start to talk about a topic and it's not clear, or you have questions and you want to just raise your hand and stop us so we can clarify a point, please do. And then more kind of general questions or even specific types of questions, we might want to have those at the end. We're going to try to leave time for any of those after we do our presentation here with the slides. So we're happy to answer those at the end. Want to say anything before we get started? No. Okay. I'll just leave the show. Okay. All right, there we go. So to talk a little bit about estate planning, and I know we just heard from someone who did it very recently. How many of you in this room have done some sort of estate planning already? Okay, that's pretty good. Okay, pretty good breakdown. So some of this you may know about and some of it might be familiar. We hope to be able to teach you some new things and to cover some new materials for you that you'll find useful. But to start out, I just wanted to kind of cover what the typical nuts and bolts of estate planning look like and what that is. Tools in estate planning, for most of us working in this field, most clients who are doing estate planning, these are the types of documents they're going to come away with, or you might already have. The power of attorney, that can be both healthcare power of attorney and also a financial power of attorney. And we'll talk about it a little more in detail, each of these. I'm just going to run down the list of sort of what makes up a standard estate plan. Living will and advanced medical directive, those documents can be separate documents in some people's cases. In others, they are one document that covers medical, more broadly, medical decisions, and also the person who has medical decision authority if you're unable to make decisions for yourself. Titling of property is a very important part of estate planning, and sometimes people don't think of that as much because it's not a document that you're going to walk away with, like a will or a power of attorney. But it's really important as far as having your whole plan work together, that the titling makes sense and that that's been paid attention to. In addition, almost everyone who does estate planning will have a will, and they will also potentially have a trust. And that's something John's going to talk about a little more in detail, but some estate plans include a revocable trust. Some also include something called a testamentary trust, which is part of your will. And we'll talk a little bit about the differences of those two documents and vehicles. Gifting is sometimes a topic of conversation in estate planning for various reasons. We'll talk a little bit more about that as well. And life insurance is, for many people, part of their estate plan. So those are the basics of what makes up an estate plan for most people. And then we're going to dive a little deeper into each document just to make you familiar with what they cover and how they kind of function. The general durable power of attorney is a document that gives authority to an agent to make decisions for you. So if any of us are incapacitated in the future, for some of you when you were out of the country, right, you're unable to deal with some things here, maybe domestically, you had a power of attorney. Your power of attorney can act on your behalf. They can do things like pay your bills, pay your mortgage. They can also do any type of business transaction that you typically can do for yourself, your agent can do for you under a power of attorney. There are two types of powers of attorney. One is a springing power of attorney, which takes effect on a certain trigger event, such as disability. For some clients, it makes them feel better to know that their agent is authorized to act for them if needed, but it's only upon a real need of you're disabled, I'm disabled, and suddenly my agent's able to keep my lights, my light bill paid and my home secure and my bank accounts paying my medical bills and things like that. So you have that aspect of it. The durable general power of attorney that many folks have is also oftentimes effective immediately. So when you sign the power of attorney, your agent is immediately able to act on your behalf. And you see that a lot as well. So there's just two types of powers of attorney that generally we talk to clients about which one makes the most sense for them, but I did want to make you aware of it, since some people feel a little bit uneasy maybe about giving up that authority to a third person other than themselves. But at the same time, it's really important document for all of us to have if we ever are in a position where we can't handle our day-to-day affairs ourselves. And for any adult, any client who comes to see me, I say this is a really important document to have. I think even John and I are seeing more and more like college kids getting these documents since they're 18 and needing them on hand too. So we've been doing some of that as well. The intent of the document is to avoid a guardianship proceeding where an individual would have to qualify in court to manage your affairs and to be appointed your guardian to manage your affairs if you don't have a document like this. And so by having this simple document in place, we can oftentimes avoid a more costly, more involved process through the courts, and that's the reason that these are really helpful. They are only effective during your life, so when a person passes away, if you're an agent for someone on their power of attorney, if they've passed away, you no longer have authority as their agent when they die. And likewise, for any power of attorney you execute, your agent is only going to have authority while you're living. And so that's just something to note. The Advanced Healthcare Directive, or the Living Will, is a document that oftentimes goes hand in hand with a medical power of attorney. The document that we include for clients is one comprehensive document. It has both the power of attorney for healthcare decisions, appointing an agent to make decisions for you if you're unable to, and then it also covers what types of decisions you want your agent to make. So things like are listed here, use of oxygen, hydration, pain medication, things of that nature are all addressed in this document. And the idea is that you put some thought into what type of care you do want to receive, and then you can communicate that to your agent and your family members, and you can also communicate that to the medical professionals if needed by this document. So it's a fairly comprehensive document, but it does lay out those types of decisions as important end-of-life care decisions that a lot of us probably don't want to think about, but really, should try to think about and memorialize if we can. Again, it's only effective during your lifetime, and for medical decisions, it's worth noting, though it may be obvious, that your agent's only empowered to act when you're unable to act for yourself. So you obviously would always have authority over your own decisions as long as you're able to communicate those wishes. Titling of property is something I touched on in the beginning. It's also a very important part of your estate planning. You want to look at how you own property and who you own it with, particularly when you have joint property. So if you have real estate that you own joint with right of survivorship with another individual, regardless of what you put in your will, with respect to that piece of real estate, your title on that real estate is really going to be the important piece of the puzzle from an estate planning perspective. So whenever you're doing estate planning, you're not only putting these documents in place, your attorney or your professional you're working with should be also looking at how you own things, what you own and how they're titled, and then making sure that that aligns with your wishes. If your intention is not for that piece of property to pass to your joint owner at your death, then there need to be other steps taken to make sure that your wishes are actually realized. And so titling is an important part of all this. Also, beneficiaries on accounts impact your estate plan. So a lot of people have done some estate planning without realizing it by having people on title, having people on accounts as beneficiaries or transfer on death. And they may not realize it, or they may forget, and they do a will and think that is going to impact all of your assets. But that is not always, that is not the case where titling contradicts what your will says. So it has to be part of your overall planning that you look at that as well. We do mention that in Virginia and DC, we do now have the ability to transfer on death deeds, which addresses titling of real estate and transferring real estate ownership without probate to a beneficiary. And for those in the room who aren't familiar with probate, that's just the administrative process of changing property from one individual's name, the deceased individual, to their beneficiary. A lot of people try to avoid probate. It's important to them to simplify that process as much as possible. So the transfer on death deeds that are available in DC and Virginia can be really helpful as far as allowing transfers to family members or transfers to other individuals without probate. And that's something that's in addition to your other planning documents you might do. So it's another tool in the toolbox to think about when you're doing your estate planning. Okay, so wills, I think, is what people think most commonly about when they think about estate planning. It's probably the first document that comes to mind, and it's oftentimes one that a fair amount of time is spent on. They are effective at death, so your will is revocable, it's changeable. As long as you have capacity to make changes, you're able to do that. And the purpose of the will is to direct where you would like your property to go at death, after death, and to whom you'd like it to go to. It also does address things like guardianship, and we do address burial wishes and things of that nature sometimes in the will as well. So it has a couple other functions, but the main function is certainly disposition of your property and making that clear for the probate process. There are also sometimes specific bequests to individuals. Let's say you want to make a gift to your church, you want to make a gift to an organization. That's often all put into your will. And it does also appoint an individual to manage your estate. So you're thinking about, which family member you would want to have manage your affairs for you. That would be also addressed in the will. Everything that passes under a will does pass through probate, that process we mentioned earlier. And John is going to speak a little bit about trust in a moment, which is a vehicle to avoid probate potentially. And we'll talk about that a little more. But with wills, most commonly, you're going to be naming your beneficiaries and your executor, and you're going to be planning your estate through that vehicle, just that one document. Without a will, you all probably know this in this room because a lot of you have done estate planning. Without a will, the state intestate laws control your estate. So if you don't make your wishes known through a will or trust mechanism, the statute for Virginia or DC or wherever you reside is going to be the one that determines where your property passes at death. And for many folks, that's not the same as what they would like to see, so they come to us and we draft the documents they need to update those wishes. Types of trust, I'm going to hand it over to John. He's going to talk a little bit about that.
Basically, with trusts, they historically had been used a lot for part of the tax planning. With the changes that occurred in the federal law in 2012 and at the end of 2017, the need for trusts for most individuals for tax purposes is no longer as strong. There really isn't a strong basis for that. There are still reasons for a trust if you have an individual in the family who has special needs that you want to provide for. If you're in a blended family, you want to make sure that the division between one part of the family and the other is followed, or if you have minor children, there are reasons still to do trust, but the tax reasons, and I'll get into more on that, have really gone away on the trust because of the increase in the exclusion amount and the introduction of portability in our federal law. So there are two types of trust. One's a testamentary trust. That's a trust you do as part of your will. Our feeling is it's not as good as the other type, which is called inter vivus among the living. The reason it isn't quite as good because you have to go through probate with that. Sometimes it's an easy way to do a trust where you think the likelihood is extremely low that you're going to need the trust. For example, you have one minor child who's 16, your other kids are older. The likelihood that something's going to happen to you in the next 2 years is not likely, so why do the full trust document? Just do a placeholder somewhat with a testamentary trust. Although you can do a full-blown trust as part of a testamentary trust. On the inter vivus trust, again, the trust among the living, Those can either be revocable or irrevocable. There's a lot of tax planning issues still available for people that are in the higher income brackets on the irrevocable. But bottom line is it's become less likely that you are going to need a trust. The will is probably going to work in more and more people's situation. And part of that was the changes that occurred in the, clicker thing, in the estate taxes and Tax Cut Jobs Act that was adopted at the end of last year. Now, to go back over some of the things, as most of you know, transfers between U.S. spouses are tax-free. They're always tax-free. If you have a non-U.S. citizen spouse, there are ways that the transfers can be made tax-free, but you have to set up a qualified domestic trust. No, you do not have to set it up currently. You can set it up after the death of the non-U.S. citizen spouse. So that provides an opportunity for money to go to the non-U.S. citizen spouse. There are rules and regulations of below a certain amount. Pretty much anybody can serve as a trustee. If it's over a certain amount, U.S. financial institutions have to serve in that role. And that's just because the government wants to get their money at some point. So that's basically why they've done that. But what happened at the end of 2017 is the federal, it's an exclusion amount, but I think most people talk about it as an exemption amount. It doubled. It basically went from 5.6 to 11.2 million. It's not exactly 11.2, but I think that's good enough for general purposes. If you're married, you can double the amount of the exclusion, and so it goes to 22.4 million. That puts most of us out of having to worry about federal taxes. Okay. So if you have an estate above that, we'd be happy to talk to you. But the rest of us, I'll just keep going. The current tax rate above that amount is 40%. Now, one of the interesting things about this act is that it sunsets in 8 years. So in 2026, unless Congress reenacts the law or reenacts a similar law, the exclusion amount is going to revert to 5.6 million and therefore it'd be 11.2. It'll be a little higher because it is indexed to inflation, but they changed how the inflation rate was calculated. So those changes, could well come back into effect. I think most commentators feel it's likely that this may stay in place simply because once people feel that they have this benefit, they'd be pushed to keep it, but because of the way it was set up, since it'll automatically go away, I wouldn't personally bet one way or the other what is going to happen. But one of the interesting things for those, for the one or two of you in this room that may have that estate because you won the lottery or because you're a great investor or something, the gift tax provides an opportunity currently to give away that amount during the time period the higher amount is in effect. So if in 2025 you were concerned that they were going to change the law, you could still, assuming they didn't change the gift tax law beforehand, you could still give a gift of the full amount that is currently excluded. The other thing that happened was portability. In 2012, Congress enacted portability. That's one of the reasons we had trust. We had trust to make sure that a lot of times, most people, if they were married, they would give everything to the spouse, or they give a large portion. So what would happen is that individual might have had a $3 million exemption or something like that, and that would have been what it was at the time. But if they gave it to the spouse, then they also have a $3 million, but they can't use their spouses because they passed everything on to them. With portability, you can double up. You can say, if the one spouse basically provides for it, the second spouse, if one of the things that has to happen is that you would have to file an estate tax return to make sure you can get the portability. But if you did that, and if you thought that would be important, particularly if you were at the point in time that the exclusion amount was going to go down, because there are a lot of people in this area, because of their house, owning it for 40 years and having some stock investments and the 403B and other things, that often push that lower threshold, the 5 million. We see that a lot. We don't see a lot of people at the 11 and the 22, but that doesn't mean you aren't out there. So there are ways to play the gift tax, I mean, making a gift now to avoid the tax sometime in the future. So portability is likely to stay in. It is, I've said before, I stayed up and watched C-SPAN that night when they were voting on it. So you had an interesting vote. Portability was the one that had the most support, because you had members of the Congressional Black Caucus whose position was that a lot of the individuals that had earned money, maybe they owned, a media outlet, or they were a sports figure or a banker who had done well, they didn't come into the world with a silver spoon in the mouth, so they didn't have advisors initially on what to do. So they wanted it because it was an easy way to do estate planning after death. And then the very conservative group who don't believe in estate taxes at all, they wanted it because it expanded the amount that could pass tax-free. So in that sense, it was one of those things that I really think portability is going to stay. Now, we'll get into later that portability does not exist in every state. So a lot of states do not have portability, so you have the same problem you did before. And that was one of the reasons you had trust, because the trust was a way to avoid, before portability, it was a tax planning tool, so that you could take the first spouse that dies exemption amount and add it on to the second spouse. So we don't have to worry about that at the present time, except for estate taxes. Now, one of the things that by raising the formula has occurred, it means that those of you, and I wouldn't be surprised if there's a number of you in this room that have a trust set up, and you had probably what they call an AB trust or a family trust and a marital trust. Because of the fact they changed the exemption amount, you need to check that. And you seriously need to check it, because a lot of times these were written when the exemption amount was at 3 million, or 3.5, or 5 million. And if the idea was to pass to the family $3 million by saying, I give the maximum amount that can be excluded under federal tax to my children or my grandchildren or something like that. At that time, the maximum amount might have been 3 million. Now it's 11.2, and that would take care of the marital trust altogether. Now, if the family trust is written that it's for the spouse and the children, you're probably still okay. But please go back, just pull it out and read it. If you don't have questions, go to the counsel who prepared it. We can look at it, other people can look at it. But it's a trap, it's an unintended consequence of raising the amount of the exemption. My bet would be that there are 2 of you in this room that would be affected by that. So it's not an insignificant situation. Let's go into the next section on estate taxes and inheritance taxes in general. Inheritance taxes on the state level, I've said this before when I was speaking here and elsewhere, they're going out. State inheritance taxes on the way out. It's not an efficient way to raise funds. Here's why. Because there are so many states that have done away with it, that what happens is people actually move from states that have a high inheritance tax to states that don't. So what happens is a state that has the inheritance tax starts they lose the income that the person, if they'd stayed in the state, would have paid for 5, 10, 15 years. They've lost that. In most cases, that tax is maybe greater than any inheritance tax. Now, there's some states that probably will never be able to, because of their tax structure, to do away with the inheritance tax. But most of them, this chart 5 years ago was half yellow.
Yeah.
So you can see what's happened. There's a few other states that are likely to, Maine is likely to change it, Connecticut is likely to change it. I don't know that New York ever will. I'm pretty sure Illinois never will. So there's some states, just because of their current financial situation, they won't. But I wouldn't be surprised 5 years from now, instead of the number of states we should have, it's half. I don't think it'll ever go away, but the trend is still downward. So let's get into the...
Is there an inheritance tax?
Yeah, the next slide.
No inheritance.
Well,
Yeah.
there's,
Right.
well, it's 5.6 million.
Right, it was just an inheritance tax.
Well,
The estate.
okay. Right. There's a difference between an estate tax and an inheritance tax. So let's go back. We'll go back to that
Yeah,
slide.
I think it's
Yeah.
next. It's almost,
Thing. What?
it's on the next slide.
Right. The inheritance tax is on the beneficiary. So the estate tax is on the estate. But a lot of people use those terms interchangeably, but they're not. So like if you may have a Virginia estate, but a beneficiary in Pennsylvania, because they do have an inheritance tax, would have to pay the tax upon receipt. So DC does not have an inheritance tax, but they do have an estate tax. So, I mean, you may have been asking about the estate tax, that's why it was a little bit. Okay. Going to the next slide, Virginia has no estate tax, so that follows the federal exactly. So that's a non-issue. Maryland has an estate tax of everything over 4 million in this year. It'll be 5 million next year. And the good thing that will occur next year, Maryland will add portability. So that will allow you not to have a trust. We've done a lot of Maryland state-specific trusts. So if the total estate is under the 5 million and they adopt portability, I think we'll be doing less of those. Now, DC had coupled their estate tax with the federal, so it went to 11.2 million, but they just reduced it this month back to 5.6. And the worst thing about DC is they do not have portability. So if it's possible that somebody could have an overall estate of 6 million, and unfortunately if it was titled all in the wife's name and she were to die first, there might be an estate tax. If they were 3 million and 3 million, you would be okay, but without portability, it makes it, the titling becomes even more important. I don't know if I've been clear on that, but if you have questions, certainly ask on it. It is changing.
And I will say one note on the materials, since this just changed back for DC on the map that we showed you, they still have the old DC exemption. So if you look at the map, it will show slightly higher DC exemption than is actually in place now. But that map just hasn't quite been updated as of September 5th. Yes.
Yes, thank you very much. So I have, let us say, I have a mutual fund with Acme Mutual Funds, and I have listed with them a couple of beneficiaries that are human beings. And as I understand it, and they live in 2 different states. They live in Minnesota and Wyoming, it doesn't matter. So if I die, that mutual fund is, question 1, is not part of my estate. So there'd be no estate tax. It wouldn't fall within the computation of whatever my estate is. That's the first question. Second question then is the two people in various states who get $50,000 from the Acme Mutual Fund, is that an inheritance tax or an income tax? Or are you going to get to this later? Because I'm trying to understand what's in an estate and what's in an inheritance when we have the capacity for some things to designate beneficiaries outside the will process.
The first distinction I would make is between your probate estate and your taxable estate.
Okay.
So the mutual fund, because of the fact it's a contractual obligation and you've designated written beneficiaries, is not in your probate estate, but it's certainly in your taxable estate. So to the extent that there's taxes, and let's take the hypothetical that one of the parties lives in Pennsylvania and the other lives in Wyoming, as you said. The Pennsylvania individual, and these inheritance taxes are state specific. Some of them don't tax brothers and sisters and children. Some do, some only, non-linear descendants, and each one's different. But let's just say this individual is just a coworker, friend. Most likely, that would be a tax, and it could be as high as 15–16%. So it's pretty hefty. The Wyoming person wouldn't have a tax, so they would actually get more. So if you wanted everybody to get the same, you would have to take that tax into account. But of course, you don't know what the government's going to do next month or next year, and they might change it. But that would be the best situation.
Can you put your IRA and mutual fund in a trust?
We don't recommend mutual funds. Yes, okay. You can have your trust own the mutual funds. We don't recommend that in terms of your IRA. There's no reason necessarily to do that because it's a contractual obligation and it goes outside of probate anyway. And what we don't want people to do is generally to provide that the mutual fund goes to a trust. If it goes, rather than individuals, spouses have the most flexibility on an IRA. Other individuals have the next level of flexibility. And if it goes in a trust, it has to be a see-through trust, which is another level of complication on the trust. So unless you have a reason to give, and you might have very good reasons. For example, you might have a trust set up for an individual that does have special needs, and you want to do it. That's maybe the only way you can do it. And then yes, I would make the beneficiary. But there really isn't a need to put the IRA in a trust. I mean, I guess if the trust were, I guess if the IRA were owning, was running a business or something, and it was a construction business, and maybe there was a high liability I could see for it. But for 99.9% of us, it would not, there's no need to. So, do you have anything to add?
No, it's the only time that I think if, like John said, the special needs situation or a minor, minor children who you can't name directly at that point in time. But even then, if you were to name the trust when they became of age to inherit outright over 18, you'd change it most likely.
The next slide is on the inheritance tax. We talked about this a little bit. There's still 6 states that have the inheritance tax. Maryland is the only one in this area, Maryland and Pennsylvania, only ones that have it. And as it says, it's paid by collateral heirs, so they're non-linear, they're non-children, spouse type of situation. So it's not likely that Maryland's going to collect it, but for some reason they keep it. So if you want to give money to a Maryland resident, just expect that there could be a tax. It could be changed at some time in the future, but right now that's exactly what would happen. So, talked a little bit before about the gift taxes and the fact that the exclusion amount was raised the same for estate taxes as gift taxes. That was part of the 2017 tax bill. The annual exclusion is now $15,000. It's gone up slightly. And it's $30,000 per spouse. So you could turn around and give $30,000 if you're married to everybody in this room, tax-free. If anybody wants to volunteer, I'll stay in the room for a little longer. But you can use that. I mean, it's a pretty powerful tool. It's one people overlook if they really do have a large estate and they're getting to a point in their life. They, obviously there's things, charitable gifts, charitable annuities, things like that are other good options, but they wanted to also give to their kids. That annual exclusion is a very inexpensive, there's no paperwork, it's just write a check and keep a copy of the check that you made. And then the annual transfers to non-U.S. citizens, it's $152,000 now. You can do that each and every year. So it'll go up a little bit next year. So if you are in a situation where your spouse or you are a non-U.S. citizen, you can encourage your spouse to give you $152,000 a year. At this point, Lauren picks up for a few items, and then I'll finish off.
Great. So the next topic we wanted to touch on was spousal rights in estate planning. This is something that does come up from time to time with clients, and for all of our clients now, it affects more people than before. So that's something that I think is important to talk about. The spousal rights for foreign service spouses is a special rule that actually applies in cases of retirement benefits for foreign service individuals. So it's a little bit complicated, the rule. I wrote it on the slide, but I'll try to summarize it clearly. Basically, unless the spouses have decided some other arrangement between them. So as a married individual, you can always agree with your spouse to consent to some sort of different distribution. But typically, any changes beyond the standard default rules require some sort of agreement, like a postnuptial agreement or something to that effect. So unless otherwise provided, a former spouse of a foreign service person is entitled to both pension and survivor benefits. And again, unless they waive that, as long as the following conditions are met. So if the former spouse divorced the participant of the plan after February 15, 1981. Also, if before commencement of payments of any benefits, the former spouse had not remarried before the age of 55. So they could have remarried before receiving benefits if they were older than 55. And the former spouse was married to the foreign service person or the former foreign service person for at least 10 years. And during that, at least 5 of those years, the participant was a member of the foreign service. So as you can see, there's a lot of, if this is met, and if this is it's kind of a complicated criteria a little bit. But as you can see, there are rules that govern things, even like, who you name as a beneficiary on your pensions if you are married. So I raised this just so you're aware of it and you know that these are the default rules that are in place. And if you and your spouse want to make some other arrangement, then it's important that you put that in writing and that you both, agree and consent to those changes and go through the proper process. Similarly, states have also decided that it's important for spouses to provide for each other through their estate plan. So they've passed legislation that makes it easier for surviving spouses to make claims against their spouse if they are not satisfied with what they're receiving under their spouse's will, or in some cases if they're not receiving anything under their spouse's will. I know it might be hard for some people in the room to imagine not providing for your spouse, and for others maybe not so hard to imagine, but Nonetheless, there are people that want to do other things with their estate, and there are people that, maybe have children from a prior marriage. It's really important that they provide for. And sometimes, and most times, when people talk to us about making these changes, they've talked to their spouse. But what people don't always realize is they need to do more than just talk and agree. They do need to be clear in their wishes, and they do need to get consent from that spouse if they're truly going to allow some sort of different distribution. In Virginia, if you disinherit a spouse, they do something called an elective share, which they can claim. And frankly, even if you include your spouse in your will, your spouse can still make this claim after the first spouse dies against the estate for the spousal elective share. We've seen some changes in Virginia on how this is addressed, and just recently, in the last, I guess, it was last year? It's only been about a year that we've had the new rules. It used to be that they looked just at the spouse who had died. They looked at their assets, and they based the share for the surviving spouse on what the deceased spouse had when they died. They've moved to maybe a more modern philosophy now that the spouse is an economic partnership. They look at both. They look at the spouse that's living, and they look at the deceased spouse assets, and they say, okay, what is a fair, equitable division of these assets based on the marriage. It's interesting, it's a 15-year period of an earn-in period, I guess if you will, or a vesting schedule of your marriage. So shorter marriages, there is a lower portion of the assets that are part of the claim, the surviving spouse. In Virginia, it's 6 months after the death of your spouse, you have to make this election. And in Maryland and DC, it is only on the probate assets of the deceased spouse. So the math and the calculation is a little different in each jurisdiction, but it's important to note if you're going to make changes to your estate plan that don't, provide fully for your spouse, or you have some other intentions, just that you talk through these rules that apply to you and make sure that you properly memorialize agreements between your spouse and yourself. Or that you are at least aware of these rules when you're going to your own planning, so that you know what the state statutes provide for. Any questions on that?
It just, going back one.
Oh, yeah.
Spouses are entitled to pension and survivor benefits. What are considered survivor benefits? It's on spousal rights.
In the first paragraph.
Yeah, I see where you're referencing, and that's a really good question. I don't know that I know which plan that would apply to. We can follow up on, I can follow up on that, because I have to look back at the actual reg to find out what it's referencing. You know?
You were talking about the
former spouse.
under the foreign service.
Right. But you're asking which survivor benefits for foreign service members we're talking about? Yeah.
I don't know particularly which ones, maybe Paula or somebody else could come in,
They're talking
like
about
an
the
insurance
health
policy.
insurance,
Yeah.
under the FEHB, the former spouse is entitled to that, but may have to pay the whole amount. So, because health insurance is a health insurance is a survivor benefit.
Thank you.
I'm not sure about this, but I think when you're retired from the foreign service and your annuity, that you could choose a survivor benefit and get less of an annuity now, and your spouse gets something. I know some people get 50%, some get more. Once you're retiree, there's something like that. Good. It's not just only health care.
There's an election.
Yeah.
You take less
It's not just health care, it's the annuity itself.
Right. And we can get some clarity on that too if it's helpful.
Well, I think you have resources in the office and in this
True.
room that can help too.
Yeah,
so.
true. Very true. Okay, so gifting strategy, something John touched on, he's going to go back to in a little more detail.
One of the things that's important when you're thinking about making a gift is the fact that when you make a gift of appreciated property, like a house, we have had people come in and say, I really want to put my daughter in my house or something, I want to do it now to make sure that she's going to get it. The problem with that is that she takes your tax basis in the property. And even though the property may be worth $700,000 now, when you bought it, it may have been 107, and that's a big difference of capital gains that she's going to have to pay. So at least in DC and Virginia, where they allow transfer on death deeds, the better way to do that, to assure that it would happen, is to do a transfer on death deed. So it's not an immediate gift, it's a gift at the time of death, and the individual receiving the gift would get a stepped up basis under current law. So their basis would be $700,000 in the hypothetical example I gave. So if they ultimately lived in it for 10 years and it went up to $1 million, they'd have to pay taxes on $300,000. But if under the other scenario, they'd be paying taxes on $893,000, if assuming the original price was $107,000. So there are definitely things to think about in gifting. The best gifts are obviously cash. Everybody knows that anyway. I mean, so, at least that's if you're receiving, I think. Then the sweater, while you may like the sweater, you don't have to worry about whether it fits or something like that. One other thing that is very powerful in terms of the annual exclusion or the annual gift that you can give, in addition to the $15,000 per person, you can also make gifts of medical expenses and tuition. The checks have to be made out to the medical provider or the college or the trade school or whatever you want to, but that would increase greatly if you've got a grandkid in college or you've got a niece or a daughter that's having medical issues. In addition to the $15,000, you can pass that to them as a gift. That is something that, again, it's overlooked. I mean, a lot of people follow it, but it's something that's overlooked. So the gifts, some people sometimes ask about gifts to the children. Because you have an obligation to provide in most states for their medical care and education, it's always kind of been that way, but now these really apply. I don't think the IRS has ever looked at gifts to kids while they're in the teenage years, as long as they're, for going to school, private school, or getting certain medical, or going to camp. They've never done that. What this means, though, is the grandparents or the nieces or the aunts and uncles can start making the gifts. So it's certainly something to keep in mind. We're in a transition right now. What are the best strategies in terms of estate planning? If we can say that we're still in a low interest rates world, and I would argue we are historically, then certain types of the annuity trust are particularly attractive. The installment sale, where you sell something and take back a note, it's not necessarily a bad way to do it. The low interest of family loans, the interest on that you would have to pay on that is set by federal law, and it's lower than, yes, it's mine, and I apologize. Thought I turned it off at an earlier meeting. So those are things to look at. As rates get higher, the whole gifting strategy in terms of from a tax perspective, although that's less important, becomes different because of the rates and the funds that you might be able to receive. The next thing that we've done is kind of show you what an interfamily loan is. That's where you're not sure you want to give the money to the grandkids or something, but you're willing to loan it to them on the basis, and you can loan it. Depends on the length of the term. If it's 3 years, it's one rate. If it's over 3 to 9, it's another. If it's over 9, It's another, but if you look at those rates, these are the current rates for next month. They're set, and 2.55, 2.83, and 2.99, it really follows fairly closely the corresponding Treasury rates. I mean, I guess Treasury today was 305 or something like that. But if you look at it at a 2-year, 5-year, and 10-year, that's a good market. And you can loan that to the family and still get income back. You can always forgive the loan in your will. I mean, if you're, but it's also a way to kind of keep a leash on some of the grandkids if you wanted to do that. So, they don't know that you're necessarily going to give it up. The next page is just potential things that are going to change in estate planning. We don't know when this will change, and we don't know for sure that it will. The first one, the inherited IRAs, it's something that's been high on Treasury's list of changes. We would not be surprised in the next 10 years, not necessarily the next 2 years, but the next 10 years, would not be surprised to have a requirement that certain inherited IRAs be eliminated out in over a 5-year period or a 7-year period. In other words, now people can take out over their lifetime, and it's even more favorable if it's a spousal. We think the spousal will continue, but we wouldn't be surprised that there's a lot of money accumulating in the IRAs. Treasury has its eye on it, so I think we particularly expect that there will be changes in that. Now, under the current administration, the IRS regulations that were proposed about 2 years ago on elimination of discounts for interfamily transfers of business interest are totally on hold. That will be the case for at least 2 more years. But after that time, it's very likely that Treasury will go back on that particular issue. So those are the 2 areas that we're just kind of repeating what most commentators are saying. We're not saying it's going to happen. But if you and some of your family members own a business together, I would certainly get the planning done now rather than 2 or 3 years later from now, because it may become retroactive or it may become only effective for new situations. So both of those are word to the wise. And unfortunately, the only way you can make your inherited IRA vested would be to die now, and I'm not suggesting that, but just figure that those gifts may have to be taken out. And why is it important that they would have to be taken out? Because it becomes taxable. When you take, that was money that was put aside, you didn't pay taxes on it. So if the beneficiary has to take it out, they're going to have to pay the income tax on the original amount. So it becomes less valuable as a gift. And right now it's a very powerful tool to continue to accumulate assets.
For the inherited IRAs, would those be for IRAs going in the future that one would inherit with ones that one had?
After death. It would be after the death of the owner of the IRA. Yes.
So it would be grandfathered for that?
I would think that if you have an inherited IRA, yes, I do believe that will be, again, going under the theory, it's very hard to take away a benefit that people have right now. It would cause a lot of controversy, and it would not be politically wise for either party to consider doing that. But something in the future to change it, I think we feel that that's likely to happen. So you doing the last one? Yeah.
So the last slide we have, and then we're happy to stay for questions, and I know we're also close on time for others who have to leave, I think. But the last slide is just when to review your estate plan. So for those of you that have it, we've recently gone through changes to tax law, to the tax code. That's definitely a trigger for review of your estate planning documents. Also your own major life changes, so divorce, birth of a grandchild, or change of location where you reside if you move to another state. Sometimes that triggers a reason just to review what's in your estate plan. Anything like that that's kind of a major life event, you want to think about your estate planning and make sure it still aligns with what you're hoping to accomplish. Also, death of a beneficiary and things like that often make people need to revisit their estate plan. If you don't have any of those major changes, we also suggest every 5 years to take a look at your estate plan, and maybe every 3 to 5 years is a better rule of thumb, but to take a look at it, read through it, make sure it still makes sense to you, make sure you still feel comfortable with it, and then if not, talk to somebody about what changes you might want to see. And that's everything for us. This is our contact information. We're happy to be contacted with questions, and we'll be happy to answer questions. Thanks, everyone. If you have other questions, we'll be here or reachable by email. Thanks for having us.
Thank you, everybody. Well, see, I just want to say thank you again for the privilege of being here and picking up, pigtailing on all this wonderful advice and facts and information, and I hope it has been as beneficial to you, and I'm sure it has. I want to thank you for the opportunity, Paula, to come do this again this year, and look forward to it in 2 more years, and hope to see you all here. Paula, would you like to say a few words before we wrap up? And we also can give proper credit to the proper person.
Thank you, Jim. Well, the credit to the proper person would be my team, which would be Kyle and Tonisha and all the people out there. So I want to thank you for putting on a great conference. So I just want to take a couple minutes to summarize. Gosh, what an important afternoon, and what an informative afternoon we spent. I can't believe it's already gotten done. Dr. Rosenfarb, who got called because he has to talk to the press, I don't envy him right now, talked about mental health and the roadblocks, and I think we got a better understanding of the potholes and the detours that we have to take. But I think that his point was we need to focus on mental health, not mental health. And I think that is a really good point to make. Ted talked about coaching. Thank you, Ted. The Foreign Service Benefit Plan, and he also works with many other federal health plans in the FEHB program, is their job is getting folks to do things they just don't want to do. And it is so important to have that buddy. You called it that you needed to get people to do things they didn't want to do. We call it a buddy. And that is exactly what the health coaching program does for all of the members of the FEHB program. I think a very exciting panel was the care management panel. Thank you so much for all the information that you provided. Especially the challenges that people face, not just as a patient, but as a caregiver. And really making sure that whoever that caregiver is up to the job. Because that's a really, really important job. And also, where do you go? Rehab, home, is it safe? All of those questions that either you can plan for, or in an emergency situation you can't plan for. And then who do you turn to? So you turn to the care managers, you turn to the foundation, and there's lots of resources there to guide and to help you make those really difficult decisions. So hopefully you've learned something about that. I'm supposed to remind people to please, when retirement sends you that customer satisfaction survey, to please respond to it. Your input is very, very important. They wrote articles for both the Senior Living Foundation and the Protective Association to give you some information about what to do and when to do it. We do have a link for their RNet on our site on the Senior Living Foundation website. And so if you need those resources, they are right there. Just go to our website and you can link into the RNet website. And with that, I do want to point out the packet that you received. There's a lot of good resources there as well. Please use them. The medication resource and the emergency, the kit is, I think, very valuable. I do want to take just 2 more minutes to thank our speakers. Again, Ambassador Grossman did mention that these wonderful, wonderful speakers came from a long way away. Jackson and Phoenix and Ohio, and they came at their expense and didn't charge the foundation anything. And we are so grateful that they care so much about our taking care of their own, of our own, that they took care of us. Also want to thank our sponsors, Aetna, Pam, thank you very much, and Express Scripts for helping us provide this wonderful service. And with that, please join us for further discussion over cocktails. I don't want to stand in anybody's way now, and that's very dangerous. And thank you so much, Jim, for once again making this a really great event. Thank you.